I woke up that Tuesday morning to find construction equipment parked at the edge of my property in rural Asheville, North Carolina, and my blood pressure spiked before I even had my coffee. My name is Grant Olson, and I have owned these 15 acres of pristine woodland for the past 8 years. I bought this property specifically because I wanted privacy, peace, and the kind of quiet you can only get when your nearest neighbor is half a mile away. The house sits on 2 acres of cleared land, while the remaining 13 acres are dense forest with old-growth oaks, maples, and a small creek that runs through the eastern section. It is my sanctuary, my retirement plan, and according to the deed in my safe, it is 100% mine. I threw on jeans and boots and marched down the gravel path that led into the woods. The morning air was crisp, carrying the scent of pine and damp earth, but all I could focus on was the mechanical whine of machinery growing louder with each step. When I reached the source of the noise, I stopped dead in my tracks. A small excavator was clearing undergrowth about 200 feet into my woods. 2 men in hard hats were marking trees with orange spray paint, and a woman with a clipboard stood nearby, gesturing and pointing like she owned the place. Behind them, I could see a cleared path stretching deeper into my forest, at least 8 feet wide, with fresh wood chips already laid down in sections. "Hey," I shouted, my voice cutting through the machinery noise. "What the hell is going on here?" The woman with the clipboard turned around, and I recognized her immediately. Deborah Winters, president of the Meadowbrook Heights HOA. My property was technically outside the HOA boundaries, which was exactly why I bought it. The subdivision was built 3 years after I moved in, sprawling across former farmland about a quarter mile from my western property line. "Good morning, Mr. Olson," Deborah said with a smile that did not reach her eyes. She was in her late 40s, with that overly styled blonde hair that suburban HOA presidents seem to favor, and she wore a navy blazer despite the physical work happening around her. "We are just putting in the new community walking trail. It will be a wonderful amenity for our residents." "On my land," I said flatly. "You are building this on my property." Deborah's smile tightened. "Actually, according to our surveyor, this path follows an easement that was established in the original county land grants. It is perfectly legal." "That is complete nonsense," I said, my hands clenching into fists at my sides. "I have the survey from when I bought this place. There is no easement. This is private property and you need to stop right now." One of the workers had shut off the excavator, and now everyone was watching our confrontation. Deborah adjusted her grip on her clipboard and pulled out a folded paper. "This is a copy of the county easement map," she said, holding it out to me. "As you can see, there is a historical right-of-way that runs through this section. It was used for logging access in the 1800s, which means it is a public access route." I snatched the paper from her hand and examined it. The map was barely legible, a photocopy of what looked like a hand-drawn survey from decades ago. The lines were vague, the landmarks outdated, and there was no way to definitively say it matched my property. "This does not prove anything," I said. "And even if there was an easement 100 years ago, that does not give you the right to come onto my land without permission and start construction." "We sent a notice to all affected property owners," Deborah said, her tone turning condescending. "If you did not receive it, perhaps you should check your mail more carefully. Now, if you will excuse us, we have work to do. This trail needs to be completed by the end of the month for our fall festival kickoff." "Stop the work," I said clearly. "Right now, or I am calling the sheriff." Deborah sighed like I was a petulant child. "Mr. Olson, there is no need to be difficult. This trail will benefit everyone in the community, including you. It will increase property values and provide a safe space for families to enjoy nature. I enjoy nature by not having strangers trampling through my woods, I shot back. You have until I count to 10 to shut down this equipment and get off my property, or I am pressing charges for trespassing and property damage. The two workers looked at each other nervously. One of them, a younger guy with a scruffy beard, started walking toward the excavator. Deborah held up her hand. "Continue working," she ordered. Then she turned back to me. "If you have a legal dispute, you are welcome to take it up with the county, but we have all the permits and approvals we need. This work is going forward." I pulled out my phone and dialed 911. Deborah's eyes widened slightly, but she held her ground. "Henderson County Sheriff's Department, what is your emergency?" the dispatcher answered. "I have trespassers on my property engaging in construction without my permission," I said, keeping my eyes locked on Deborah. "I need a deputy at 4782 Mountain Laurel Road immediately." I gave the dispatcher the rest of the information and hung up. Deborah's confident smile had slipped a bit, but she rallied. "This is ridiculous," she said. "We are not trespassers. We have legal authority to be here." "Then you can explain that to the sheriff," I replied. The workers had stopped again, clearly uncomfortable with the situation. The next 20 minutes were tense and silent except for the birds and the distant sound of traffic on the highway. I stood with my arms crossed, making sure no one touched any equipment or moved an inch further into my woods. Deputy Martinez arrived in a marked SUV, parking on the dirt access road that led into my property. He was in his 30s, professional, and looked like he did not want to be dealing with a property dispute on a Tuesday morning. "Morning, folks," he said, hooking his thumbs into his duty belt. "Someone want to tell me what is going on?" Both Deborah and I started talking at once. Martinez held up a hand. "One at a time. Sir, you called it in." "What is the problem?" "These people are on my property without permission, clearing my woods for some kind of trail," I explained. "I never gave authorization and they refused to leave." Martinez nodded and turned to Deborah. "Madam," Deborah handed him the same photocopied map she had shown me. "Deputy, we are the Meadowbrook Heights Homeowners Association. We are building a community walking trail along a historical easement that runs through this area. We have all the proper permits from the county planning department. This is completely legal." Martinez studied the map for a long moment, then looked around at the property. "Do you have the actual permits with you?" Deborah hesitated. "They are at the HOA office. I can have someone bring them." "And sir, do you have your property deed and survey?" "In my house," I said. "I can get them right now." "Please do," Martinez said. "And madam, I am going to need to see those permits. Until I can verify the legal situation, I need all work to stop." "This is outrageous," Deborah protested. "We are on a tight timeline. Every day of delay costs the HOA money." "That may be," Martinez said, his tone firm but polite. "But if there is a legitimate property dispute, I cannot allow work to continue until it is resolved. Get me those permits." I hurried back to the house, my heart pounding with a mixture of anger and vindication. In my home office, I pulled out the fireproof safe where I kept important documents and retrieved the folder containing my property deed, the survey from 2016, and the title insurance policy. When I got back to the woods, Deborah was on her phone, speaking in clipped, angry tones. Martinez reviewed my documents carefully, comparing the survey to the property markers and the vague easement map Deborah had provided. "Mr. Olson, according to your survey, there is no recorded easement on this property," he said finally. "The deed is clear, and the boundaries are well marked." "What about the historical access route?" Deborah demanded, having finished her phone call. "That supersedes modern surveys." "Madam, I am not a lawyer or a land surveyor, Martinez said. But what I can tell you is that without clear documentation showing you have the right to be here, this is legally private property, and the owner has the right to exclude you. My recommendation is that you stop work immediately and resolve this through the proper legal channels. Deborah's face flushed red. The HOA has already spent $12,000 on this project. We have contracts with the construction company. You cannot just shut us down. I am not shutting you down, Martinez said calmly. I am telling you that if you continue to work on property where your legal right to be there is in dispute, you could be charged with trespassing and property damage. That is your choice to make. The deputy looked at the construction workers. Gentlemen, I would advise you to leave until this is sorted out. The younger worker was already packing up his tools. The other one looked at Deborah, who gave a sharp nod. Fine, she said coldly. We will be back with a court order. And Mr. Olson, you will be hearing from our attorney about your obstruction of a public amenity project and your harassment of HOA volunteers. Looking forward to it, I said. The crew packed up their equipment over the next half hour. I watched every minute of it, making sure they did not damage anything else on their way out. Martinez took statements from both of us and photos of the area before he left. Mr. Olson, my advice is to get a lawyer involved sooner rather than later, he said before he drove off. Property disputes can get messy. Already planning on it, I assured him. After everyone was gone, I walked the full length of the path they had started cutting through my woods. It stretched about 300 feet, winding between trees they had marked for removal and cutting right through an area where I had seen deer bedding down. The damage was not catastrophic yet, but another week of work, and they would have destroyed a significant portion of the forest ecosystem. I spent the rest of the morning taking detailed photos and measurements, documenting everything. Then I sat down at my computer and started researching property lawyers in Asheville. I found a firm called Patterson and Reed that specialized in real estate disputes and land use cases. Their reviews were solid, and they had experience dealing with HOA conflicts. I called and explained the situation to a paralegal who took notes and said an attorney would call me back within 2 hours. True to their word, my phone rang 90 minutes later. Mr. Olson, this is James Reed, a calm, professional voice said. I understand you are having an issue with an HOA building on your property. I walked him through everything that had happened that morning, sending him photos and documents via email while we talked. Reed listened carefully, asking pointed questions about the timeline, the permits Deborah had mentioned, and whether I had received any prior notice. I never got any notice, I told him. I checked my mail as soon as the deputy left. Nothing from the HOA, nothing from the county. That is important, Reed said. North Carolina law requires proper notice for any taking or use of private property, even if there is a legitimate easement claim. And from what you are describing, their easement claim sounds dubious at best. So what do I do now? First, I am going to file for an emergency temporary restraining order to prevent them from returning to your property until this is resolved, Reed explained. Second, we are going to send a cease and desist letter to the HOA and request copies of all permits and documentation they claim to have. Third, we are going to do our own title search to make absolutely certain there are no easements or encumbrances on your property that you are not aware of. How much is this going to cost me? I asked, though at that moment I did not care. No one was going to steal my land without a fight. My retainer is $5,000, Reed said. Depending on how complicated this gets, we could be looking at anywhere from $10,000 to $30,000 in total legal fees if it goes to court. But many of these cases settle once the other party realizes they do not have the legal standing they thought they did. Let us do it, I said. Whatever it takes. We spent another 30 minutes going over details and strategy. Reed said he would have the restraining order filed by end of business, and that I should post no trespassing signs at all entry points to my property, including the area where the HOA had been working. After hanging up, I drove into town to the hardware store and bought a dozen heavy-duty no trespassing signs, along with posts and a post hole digger. I spent the afternoon placing them around my property perimeter, making absolutely certain that anyone approaching would see multiple warnings. I put extra signs right at the entrance to the path the HOA had started cutting. That evening, I got an email from Reed. The restraining order had been filed, and we had a hearing scheduled for Friday morning. The HOA had been served with notice, along with a cease and desist letter demanding they provide all legal documentation supporting their easement claim. I poured myself a bourbon and sat on my back porch, looking out at the darkening woods. The peace and quiet I had bought this place for felt violated now, but at least I was fighting back. Wednesday morning arrived with an unwelcome surprise. I was eating breakfast when I heard vehicles on my access road. Looking out the window, I saw a white pickup truck with Meadowbrook Heights HOA magnetic signs on the doors. Behind it was a small sedan. I grabbed my phone and headed outside. The truck had parked right next to one of my new no trespassing signs. Deborah got out, along with two other people. One was a man in his 60s wearing expensive golf attire, and the other was a younger woman with a leather portfolio. "Mr. Olson," Deborah called out as I approached. "This is Richard Mayfield, our HOA treasurer, and Susan Chen, our attorney." "You are trespassing," I said bluntly. "I have posted signs, and there is a restraining order being processed." Susan Chen stepped forward. She was professional and composed, probably in her mid-30s. "Mr. Olson, we received your attorney's letter. We are here to attempt a resolution before this becomes a costly legal battle for everyone involved." "The resolution is simple," I said. "Stay off my property." "Perhaps we could speak inside," Chen suggested. "There may be a compromise that works for all parties." Against my better judgment, I agreed. I did not invite them to sit, keeping everyone standing in my living room. I also kept my phone in my hand, recording app running in my pocket. "Here is the situation," Chen began, pulling documents from her portfolio. "The Meadowbrook Heights HOA has documentation of a historic logging road that ran through this area in the 1890s. That road was used for timber access and, according to county records, was designated as a public right-of-way." "I have seen your documentation," I said. "It is a blurry photocopy that proves nothing. We also have testimony from 3 longtime residents of Henderson County who remember their grandparents speaking about the old logging trail," Chen continued, ignoring my interruption. "And the county planning department approved our trail construction based on the historical record." "Then the county made a mistake," I said. "My property has no easement. I have a clear title." Richard Mayfield spoke up for the first time. His voice had that entitled tone that wealthy retirees often develop. "Look, Mr. Olson, we are trying to build something for the community here. This trail is going to provide a safe place for children and families. Are you really going to be the person who ruins that out of selfishness?" "Selfishness," I repeated, my voice rising. "You are trying to steal my land. That is not selfishness. That is property rights." "No one is stealing anything," Deborah said. "We are simply utilizing an existing public easement, which does not exist on my property," I countered. "And even if it did, you sure as hell did not follow proper procedures. I never received notice. You just showed up and started tearing up my woods. Chen held up her hand. That is actually why we are here. We are prepared to offer compensation for our procedural errors. The HOA is willing to pay you $10,000 for the inconvenience and to establish a formal access agreement. I stared at her. You want to pay me $10,000 to let you destroy part of my forest? To allow the community to enjoy a walking trail that follows a historical route, Chen corrected. You would still own the land. We would simply have an easement for recreational access. The trail would be maintained by the HOA, so there would be no cost to you. And I would have strangers walking through my property whenever they wanted, I said. No, absolutely not. 20,000, Mayfield said. That is more than fair. You could offer me 200,000 and the answer would still be no, I told them. I bought this property for privacy. That is not for sale. Deborah's expression hardened. We were hoping to avoid litigation, but if you are going to be unreasonable, we will see you in court, and when we win, you will get nothing. Then I will see you in court, I said. Now get off my property before I call the sheriff again. Chen tried one more time. Mr. Olson, please consider the offer. Legal fees alone could cost both parties more than we are offering. This is a generous settlement. No means no, I said, walking to the door and opening it. Leave. They left, but not before Deborah paused at the door. You are going to regret this, she said quietly. The HOA has resources you cannot imagine. We will bury you in legal fees until you have no choice but to settle. Looking forward to it, I said, and shut the door in her face. I immediately called James Reed and told him about the visit and the settlement offer. 20,000 is insulting, Reed said. Based on your property value and the loss of use, I would not recommend settling for anything less than 100,000, and even then, I think we can beat them in court. But it is your decision. We fight, I said. Good, Reed replied, because their attorney made a mistake. By offering you money, they are essentially admitting they do not have a clear legal right to the easement. If they were confident in their claim, they would not be trying to buy you off. Friday morning, I put on my only suit and drove to the Henderson County Courthouse in Hendersonville. The building was a modern structure with too much glass and not enough character, but the courtroom itself was traditional enough. James Reed met me outside, carrying a leather briefcase that looked like it had seen 1,000 courtrooms. He was in his 50s, with silver hair and the confident bearing of someone who knew his business. How are you holding up? He asked. Ready to win, I said. Inside, Deborah, Mayfield, and Susan Chen were already seated with their team. I noticed they had brought additional people, including someone who looked like a professional surveyor. Judge Patricia Morrison presided, a no-nonsense woman in her 60s who had a reputation for being fair but tough. She called the hearing to order and asked both sides to present their arguments for and against the temporary restraining order. Reed went first, laying out the facts clearly. I owned the property with a clear title. No easement was recorded. The HOA had entered my land without permission and begun construction. I had not been properly notified. We were simply asking the court to prevent further trespass until the underlying legal questions could be resolved. Susan Chen countered with their historical easement claim, presenting the photocopied map and affidavits from the 3 elderly residents who claimed to have heard stories about the old logging road. Judge Morrison examined the documents carefully. Miss Chen, this map is barely legible. Do you have the original? It is in the county archives, Your Honor, Chen said. We can request access, but the archives are only open by appointment and there is currently a backlog. How convenient, Reed muttered, just loud enough for the judge to hear. And these affidavits, Morrison continued, are based on hearsay. These witnesses do not have direct knowledge of the easement, only stories they heard as children. Your Honor, oral history is admissible evidence in property disputes involving historical claims, Chen argued. The logging road was common knowledge in the community. Perhaps, Morrison said, but common knowledge does not override recorded property rights. Mr. Reed, does your client's title insurance policy address easements? Yes, Your Honor, Reed said, standing. The title insurance policy explicitly guarantees that the property is free and clear of all easements, encumbrances, and right-of-ways. If the HOA's claim were legitimate, the title insurance company would have discovered it during their search. Morrison nodded slowly. Miss Chen, did your client perform a title search before beginning construction? There was a pause. Chen glanced at Deborah, who looked uncomfortable. We relied on the county planning department's approval, Chen said finally. That is not a title search, Morrison said flatly. And it does not give you the right to enter private property without the owner's consent. I am granting the temporary restraining order. The HOA is prohibited from entering Mr. Olson's property or conducting any work until this matter is fully litigated. We will schedule a full hearing for 4 weeks from today. Both parties will have time to conduct proper surveys, research, and discovery. This court is adjourned. The gavel came down, and I felt a wave of relief wash over me. Reed shook my hand. First round goes to us, he said. But they are not going to give up easily. We need to use these 4 weeks to build an ironclad case. Over the next few days, Reed's firm conducted an extensive title search going back 150 years. They also hired an independent surveyor to map my property and compare it against every historical record they could find. The results came back exactly as I expected. No easement had ever been recorded on my land. The supposed logging road, if it existed at all, ran through a neighboring parcel that was now part of a state forest preserve. They have the wrong property, Reed explained when he called me with the findings. The historical logging road they are referencing is about half a mile south of your land. Either they made a mistake, or they are deliberately misrepresenting the facts to justify their trail. Can we prove that? I asked. Our surveyor is willing to testify, and we have the historical maps to back it up, Reed said. This is going to be a short trial, but the HOA was not done fighting. 2 weeks before the scheduled hearing, I received a notice that the HOA had filed a countersuit against me for harassment, emotional distress, and interference with a public project. They were seeking $50,000 in damages. This is a slap suit, Reed explained when I called him in a panic. Strategic lawsuit against public participation. They are trying to intimidate you into dropping your case by burying you in legal costs and stress. It is a common tactic. Can they do that? I asked. They can file it, but it will get thrown out, Reed assured me. North Carolina has anti-slap laws. We will file a motion to dismiss, and if the judge agrees it is frivolous, the HOA will have to pay your legal fees for defending against it. So they might end up paying me. Exactly. Despite Reed's confidence, the stress was getting to me. I was not sleeping well, and every car that drove down my road made me tense. I kept checking the woods for signs of trespassers, and I had installed a trail camera near the entrance to the aborted path to document any violations of the restraining order. 3 days later, the camera caught something. At 2 in the morning, a figure in dark clothing had entered my property and spray painted over several of my no trespassing signs. I could not identify who it was from the grainy night vision footage, but the vandalism was clear. I took the SD card to the sheriff's department and filed a report. Deputy Martinez reviewed the footage and agreed to increase patrols in the area, but without a clear identification, there was not much they could do. "This is escalating," Martinez warned. "If you are having an ongoing dispute with the HOA, you need to be careful. Some of these neighborhood associations get obsessive." "I am just trying to protect my property," I said. "I understand that, and you are within your rights," Martinez said, "but watch your back." His warning proved prescient. The following week, I received a citation from Henderson County Code Enforcement claiming that my property was in violation of county land use regulations. According to the citation, I had failed to maintain proper fire breaks in my forested land and was creating a public safety hazard. It was absurd. The regulations they cited applied to commercial timber operations, not private residential property. But it required me to respond within 30 days or face fines of $500 per day. I forwarded the citation to Reed, who was not surprised. "The HOA has someone on the county planning board," he said. "They are using every bureaucratic tool they can to pressure you. Do not worry, we will fight this too." The hits kept coming. The next day, I received a letter from my insurance company informing me that there had been a complaint about my property, and they needed to conduct an inspection before renewing my homeowner's policy. Then the county sent a notice that they were reassessing my property taxes based on new information about land use. I was being attacked from every angle, and it was clearly coordinated. The HOA was using their connections and resources to make my life hell. "This is what Deborah meant when she said they would bury me," I told Reed during an emergency consultation. "They are trying to bankrupt me with fees and legal costs. And this is exactly what we are going to present to the judge," Reed said. "This pattern of harassment strengthens our case and supports our anti-SLAPP motion. Document everything. Every letter, every citation, every interaction. The more evidence we have of their campaign against you, the worse they look in court." The night before the hearing, I barely slept. I kept going over everything in my mind, wondering if I should have just taken their $20,000 and been done with it. But every time I thought about giving up, I remembered why I bought this land in the first place. It was mine. I had worked my whole life to afford a place where I could have peace and privacy, and I was not going to let some power-hungry HOA take it from me. The hearing was scheduled for 9 in the morning. I arrived at the courthouse at 8:30, and Reed was already there with 2 associates carrying boxes of documents and exhibits. "We are ready," he assured me. "Just answer the questions honestly and stay calm no matter what their attorney says." The courtroom was more crowded than I expected. In addition to the HOA's legal team, there were at least a dozen Meadowbrook Heights residents in attendance, all wearing matching blue T-shirts that said, "Support Community Trails." Deborah had organized them like it was a sporting event. Judge Morrison took the bench and reviewed her notes before looking up at both parties. "We are here to determine whether the defendant HOA has the legal right to construct a walking trail across the plaintiff's property," she began. "This is a bench trial. I will hear evidence from both sides and render a decision. Mr. Reed, you may begin." Reed presented our case methodically. He called the surveyor first, who testified about the historical property lines and explained in detail why the supposed logging road could not possibly have run through my land. He showed maps, documents, and aerial photographs dating back to the 1950s that clearly depicted the actual location of the historical trail. "The HOA's claim is based on a fundamental geographic error," the surveyor concluded. "The logging road they reference is located on what is now state forest land, approximately 2,600 feet south of Mr. Olson's property." Chen Cross examined aggressively, trying to poke holes in the surveyor's methodology, and suggesting that historical boundaries might not have been precisely measured. But the surveyor held firm, backed by documentation that was far more credible than the HOA's blurry photocopied map. Next, Reed called me to the stand. I testified about discovering the construction crew on my property, the lack of any notice, and the subsequent harassment campaign. Mr. Olson, after you filed this lawsuit, did you experience any unusual contact from county agencies? Reed asked. Yes, I said. I received a code enforcement citation for violations that do not apply to my property, a letter from my insurance company about a mystery complaint, and a notice of property tax reassessment, all within 2 weeks of filing suit. And had you ever received such notices before? Never. Not once in 8 years of ownership. Chen objected, claiming the county actions were irrelevant to the easement dispute, but Morrison overruled her. I will decide what is relevant, the judge said. Continue. Reed introduced evidence of the countersuit, the vandalism caught on my trail camera, and emails he had obtained through discovery showing communication between Deborah Winters and various county officials. The emails did not explicitly say harass Grant Olson, but the timing and coordination were damning. When it was Chen's turn to present the HOA's case, she called Deborah Winters to the stand. Miss Winters, why did the HOA decide to build this walking trail? Chen asked. To provide a safe recreational space for our community, Deborah said, her voice dripping with rehearsed sincerity. We have many families with young children, and the roads around Meadowbrook Heights are narrow and dangerous for walking. We wanted to give them access to nature. And why this specific location? Because the historical records showed a public right-of-way through the area, Deborah explained. We did our due diligence. We consulted with the county planning department, hired a historian to research the old logging roads, and followed all proper procedures. Did you attempt to contact Mr. Olson before beginning construction? Yes, Deborah said firmly. We sent certified letters to all property owners who might be affected by the trail. If Mr. Olson did not receive his notice, that is not our fault. Reed stood for cross-examination, and I could see he was ready for this. Miss Winters, you say you sent a certified letter to Mr. Olson. Do you have proof of mailing? Deborah hesitated. It would be in our records. I am asking if you have it here now. Not with me, no. In fact, you do not have any certified mail receipt because you never sent one, did you? Reed said, his voice sharp. We sent notification, Deborah insisted. If the receipt was not filed properly, that is an administrative error. An error that conveniently prevents Mr. Olson from having any advance warning before you trespassed on his property, Reed said. How much did the HOA spend on the trail construction before being stopped? About $12,000. And how much have you spent on legal fees fighting Mr. Olson? Chen objected. Relevance goes to motive, Your Honor, Reed argued. The HOA is trying to justify their unauthorized use of private property by claiming it is too expensive to back down. I will allow it, Morrison said. Deborah looked uncomfortable. I do not have exact figures. Your treasurer would know, correct? Reed asked. Mr. Mayfield, who is in the courtroom today. Chen stood quickly. Your Honor, we are not required to disclose our legal expenses. You are if it demonstrates a pattern of bad faith, Reed countered. But I will move on. Miss Winters, after Mr. Olson filed suit, did you have any contact with Henderson County Code Enforcement? I may have spoken with someone there, Deborah admitted, about Mr. Olson's property. I expressed concerns about fire safety in the area, yes. Based on what? Had you inspected his property? No, but so you filed a complaint about property you had never inspected immediately after he sued your organization, Deborah's face reddened. I was acting in the interest of public safety. Reed smiled coldly. Of course you were. The cross-examination continued for another 20 minutes, with Reed systematically dismantling Deborah's credibility. By the end, she looked flustered and angry, her composure completely gone. Chen tried to recover by calling the 3 elderly residents who had provided affidavits about the logging road. They were sympathetic witnesses, grandmotherly types who spoke about their childhoods in rural North Carolina. But under cross-examination, Reed got each of them to admit they had never actually been to my property and could not say with certainty where the old logging road had run. I just remember Granddad talking about floating timber down to the mill, one woman said. He mentioned a trail through the woods, but I was just a little girl. I do not know exactly where it was. By the time testimony concluded, it was almost 5 in the evening. Judge Morrison announced she would take the matter under advisement and issue a written ruling within 2 weeks. Court is adjourned, she said. Outside the courthouse, Deborah confronted me in the parking lot with several of her blue-shirted supporters. You should be ashamed of yourself, she said loudly. You are destroying a community project because of your own selfishness. I am protecting my property rights, I said, trying to walk past her to my truck. You are a miserable old man who does not care about anyone but himself, Deborah continued, her voice rising. We offered you money. We tried to compromise, but you just want to make everyone's life difficult. Deborah, you literally trespassed on my land and started building without permission, I said, turning to face her. You are the one who made this a legal battle. We had the right to be there, she shouted. Then why did the judge not agree with you? I shot back. One of the HOA supporters, a middle-aged man with a red face, stepped forward. Maybe we should just finish the trail anyway. What is he going to do about it? That would be violating a restraining order, I said. But please try it. I would love to see you explain it to the judge. Reed appeared at my elbow. Mr. Olson, let us go. Do not engage. We walked to our vehicles while Deborah continued ranting behind us. I could hear her saying something about organizing a protest, but I was too tired to care anymore. How do you think it went? I asked Reed. I think we won, he said confidently, but let us wait for the judge's ruling before celebrating. The next 2 weeks were agonizing. Every day I checked my mail and email for the decision. I tried to distract myself with normal life, working in my garden and taking long walks through my woods, always careful to document that they remained pristine and undisturbed. I found myself stopping at the spot where the HOA had started their trail, where wood chips and disturbed earth marked the scar they had left. Nature was already beginning to reclaim it. Small plants were sprouting, and the fallen leaves from the oak trees were covering the evidence. In a few years, you would never know anyone had been there. That was what I wanted. For my land to remain wild and untouched, a sanctuary for the wildlife and for me. Was that really so selfish? On a Wednesday morning, 13 days after the hearing, I got the call from Reed. We won, he said simply. The judge ruled in our favor on every point. The HOA has no easement, their claim was based on misidentified land, and their construction constituted trespassing and property damage. The restraining order is made permanent, and they are ordered to restore your property to its original condition. I sat down heavily in my kitchen chair. We really won, completely, and there is more. The judge agreed that the countersuit was a slap suit and dismissed it with prejudice. The HOA has to pay your legal fees for defending against it. That is about $8,000. What about all the harassment, the code enforcement, and everything? The judge noted it in her decision and said the HOA's conduct was troubling and potentially actionable. She did not issue sanctions, but it is a strong statement. If they try anything else, we can use her language to support a harassment claim. I felt tears welling up in my eyes. I am not usually an emotional man, but the stress of the past month had been crushing. "Thank you," I said. "Thank you so much." "You are welcome," Reed said. "I will send you the full decision. It is actually a pretty scathing read." Judge Morrison did not hold back. That evening, I read the entire 23-page decision. Morrison had indeed been thorough and harsh. She wrote that the HOA had shown reckless disregard for property rights and had engaged in a coordinated campaign of harassment designed to coerce settlement. She noted that Deborah Winter's testimony had been inconsistent and evasive, and that the HOA's evidence of an easement was insufficient to overcome even the lowest burden of proof. The decision concluded, "Property rights are fundamental to our legal system. An organization's desire to create community amenities, however well-intentioned, does not grant them the authority to appropriate private land without clear legal authority and proper procedure." The defendant HOA failed on both counts. Their conduct after being challenged suggests an attitude of entitlement incompatible with the rule of law. I posted the decision on my refrigerator where I could see it every day. The HOA had 30 days to appeal, but Reed did not think they would. "They would have to show the judge made an error of law," he explained. "And Morrison's decision is airtight. If they appeal and lose, they will owe you even more in legal fees. Plus, their members are probably furious about how much this has already cost them." He was right. 2 weeks after the decision, I received a formal letter from the Meadowbrook Heights HOA board. It was not from Deborah. It was signed by Richard Mayfield, the treasurer. The letter stated that the HOA was accepting the court's decision and would not appeal. They apologized for the misunderstanding regarding the property boundaries and assured me that the trail project had been permanently canceled. The letter also informed me that Deborah Winters had resigned as HOA president effective immediately. There was no mention of the harassment campaign, the vandalism, or any of the other tactics they had used. Just a sterile corporate apology that admitted nothing while technically complying with the court order. A week later, a landscaping crew showed up at my property with a work order from the HOA to restore the damaged area. I supervised their work carefully, making sure they only touched the areas that had been disturbed and did not exceed their mandate. They removed the wood chips, replanted native vegetation, and did their best to make the forest look like it had never been touched. It was not perfect. You could still see where the earth had been disturbed, and the new plants would take years to mature. But it was something. After they left, I walked the perimeter of my property one more time, checking every boundary marker and every no trespassing sign. Everything was intact. Everything was mine again. I thought that would be the end of it, but life had one more twist in store. 3 months after the court decision, Deputy Martinez knocked on my door. He looked uncomfortable, which immediately put me on edge. "Mr. Olson, I need to inform you that we have opened an investigation into the vandalism of your property," he said. "We received new information." "What kind of information?" I asked. "We got an anonymous tip that included a statement from a witness who saw the vandalism take place," Martinez explained. "According to this witness, it was Deborah Winters who spray painted over your signs." I stared at him. "Deborah herself." "That is what we are investigating. The witness claims they saw Miss Winters on your property in the early morning hours on the date the vandalism occurred. They did not come forward earlier because they were afraid of retaliation." "Can you prove it was her?" I asked. "We are working on it," Martinez said. If the witness testimony is credible and we can corroborate it, we will file charges: vandalism and trespassing in violation of a restraining order. I just wanted to give you a heads up." 2 weeks later, Deborah Winters was arrested and charged with criminal trespassing and vandalism. The story made the local news, and suddenly, the whole saga was public knowledge. The comments on the news website were overwhelmingly in my favor, with people expressing outrage that an HOA president would go to such lengths. Deborah pleaded not guilty and hired a criminal defense attorney, but the evidence was solid. The anonymous witness turned out to be her own neighbor, someone who had been walking their dog and saw Deborah leaving in her car at 2:30 in the morning. When questioned later about where she had been that night, Deborah had lied to the police, claiming she was home asleep. That lie became proof of consciousness of guilt. The case went to trial in district court. I was not required to testify since I had not witnessed the vandalism myself, but I attended every day of the proceedings. Deborah's defense was that she had been out driving because she could not sleep and had gone nowhere near my property. But her neighbor testified clearly and credibly, and the prosecution presented cell phone tower records showing Deborah's phone pinging off the tower nearest my property at the time of the vandalism. The jury deliberated for less than 2 hours before returning a guilty verdict on both counts. Judge Morrison, who had been assigned the criminal case as well, did not show any mercy at sentencing. "Miss Winters, you held a position of trust in your community," Morrison said from the bench. "Instead of using that position responsibly, you chose to harass a private citizen for exercising his legal rights. Even after a court order explicitly prohibited contact with Mr. Olson's property, you deliberately violated that order to vandalize his signs. This was not a momentary lapse in judgment. This was a calculated act of retaliation. I am sentencing you to 90 days in the county jail, suspended pending completion of 2 years of supervised probation, 200 hours of community service, and restitution to Mr. Olson for the cost of replacing the damaged signs. You are also prohibited from having any contact with Mr. Olson or his property for the duration of your probation." Deborah's face was pale as she listened to the sentence. Her attorney started to object, but Morrison cut him off. "Be grateful I suspended the jail time," the judge said coldly. "If you violate the terms of your probation, you will serve every day of those 90 days. Court is adjourned." I walked out of the courthouse into the bright North Carolina sunshine feeling a sense of closure I had not expected. It was over. Really, truly over. James Reed was waiting by his car in the parking lot. "Congratulations," he said, shaking my hand. "You won everything. The civil case, the anti-SLAPP motion, and now the criminal case." "I did not win the criminal case," I pointed out. "The state did." "Sure, but justice was served and that matters," Reed said. "How are you feeling?" "Tired," I admitted. "But good. I think I can finally relax now." "You should," Reed agreed. "This is as complete a victory as I have ever seen in a property dispute. Your land is yours. The HOA will not bother you again, and their former president has a criminal record. I do not think it gets better than that." I drove home slowly, taking the long way through the winding mountain roads. The leaves were turning, painting the hillsides in brilliant reds and golds. It was the time of year I loved most in western North Carolina, when the tourists came to see the fall colors and the air turned crisp and clean. When I got home, I made myself a sandwich and took it out to the back porch. The woods stretched out before me, peaceful and undisturbed. I could hear a creek bubbling somewhere in the distance and the call of a hawk overhead. This was why I bought this place, this moment, this peace. Over the following months, life returned to normal. The no trespassing signs weathered and faded, becoming part of the landscape. I never saw anyone from Meadowbrook Heights on my property again. In fact, I rarely thought about the whole ordeal unless someone asked me about it. Word had spread in the area about what happened, and I became something of a folk hero to other rural property owners who had dealt with encroaching development and HOA overreach. I got calls from a few people asking for advice on their own property disputes. I always referred them to James Reed. One afternoon in early spring, almost a year after the original confrontation, I was working in my garden when I heard a car coming up the drive. I tensed instinctively, old habits dying hard, but it was just a regular sedan with a woman I did not recognize behind the wheel. She parked and got out, looking nervous. She was in her 40s, professionally dressed with kind eyes. "Mr. Olson, I am sorry to bother you," she said. "My name is Patricia Fellows. I am the new president of the Meadowbrook Heights HOA." I set down my gardening tools and walked over, keeping a polite distance. "What can I do for you?" I asked carefully. "I wanted to apologize in person for what happened last year," Patricia said. "I was not on the board then. I only moved to Meadowbrook Heights 6 months ago. When I learned about what the previous leadership did to you, I was horrified." "That is kind of you to say," I said, not sure where this was going. "I am trying to rebuild trust between the HOA and the community," Patricia continued. "Part of that is making amends for past mistakes. I wanted you to know that we have completely reformed our procedures. We now require legal review before any construction project, and we have implemented strict rules about how we interact with neighboring properties. What happened to you will never happen again." "I appreciate that," I said, and I meant it. "Though I hope you understand I am still going to keep my no trespassing signs up." Patricia laughed, a genuine warm sound. "I would not expect anything less. I also wanted to ask if there is anything the HOA can do to make things right. I know the previous board paid some restitution, but if there is anything else, please let me know." I thought about it for a moment. "Actually, there is one thing," I said. "There is a small nature preserve about 3 miles from here, run by the county. They have hiking trails, but are always looking for volunteers for maintenance and conservation work. If your HOA really wants to provide outdoor recreation for your residents, maybe you could partner with the preserve instead of trying to build your own trails." Patricia's face lit up. "That is a wonderful idea. I will bring it to the board immediately. Thank you, Mr. Olson." She left, and I went back to my gardening. It felt good to turn something negative into something constructive. I never heard from the Meadowbrook Heights HOA again. According to local news, they did partner with the county preserve, and their residents now volunteer there regularly. The trail they wanted to build through my woods was forgotten, replaced by something that actually benefited the community without trampling on anyone's rights. Deborah Winters completed her probation and moved away from the area. I heard she relocated to Florida, probably looking for a fresh start where no one knew about her criminal record. As for me, I am still here on my 15 acres in the mountains of North Carolina. My woods are still wild and beautiful, unmarred by walking trails or unwanted visitors. The deer still bed down in the clearing, the creek still runs clear and cold, and the hawks still circle overhead. I learned a lot from that ordeal. I learned that property rights matter, and that standing up for yourself is worth the cost and the stress. I learned that there are people who will try to take what is yours if you let them, hiding behind community benefits and legal loopholes. But I also learned that the system, when it works properly, protects the little guy against institutional bullies. Most importantly, I learned that my peace and privacy were worth fighting for. Some people might call that selfish. I call it knowing the value of what you have and refusing to let anyone take it away. Every morning I still wake up, make my coffee, and walk out onto my back porch to look at my woods. They are mine. Every tree, every inch of soil, every creature that lives there. And no HOA, no matter how determined or well-funded, is ever going to change that. The legal bills were worth it. The stress was worth it. The months of anxiety and confrontation were worth it. Because in the end, I won not just a court case but the right to live my life the way I choose, on my own land, without interference. That is the American dream as far as I am concerned. Not a white picket fence in a subdivision with an HOA telling you what color you can paint your mailbox. But the freedom to own a piece of this beautiful country, and to protect it from those who would take it for their own purposes. So if you are reading this and facing your own battle with an HOA or any other organization trying to infringe on your property rights, my advice is simple. Stand your ground. Document everything. Get a good lawyer. And do not let anyone intimidate you into giving up what is rightfully yours. The law is on your side if you are in the right. It might take time, it might cost money, and it might be stressful. But in the end, justice has a way of prevailing. I am living proof of that. Now, if you will excuse me, I have some trees to check on and a creek to sit by. My woods are calling. And unlike the Meadowbrook Heights HOA, they are welcome here anytime they want.